At the close of the daily docket inside the Greenwood County Magistrate Court in Eureka, Kansas, courtroom cameras caught an unexpected moment between Judge Phyllis Webster and County Attorney Jill Gillette. The two were discussing several defendants who had failed to appear for their scheduled hearings, when Judge Webster uncovered a procedural error that prevented her from taking any legal action against them. Her discovery quickly turned tense. The judge implied that the mistake may have originated from the county attorney's office. What followed was an exchange that started as a routine discussion but escalated into a confrontation that could have serious consequences for Attorney Gillette's career.
Tanya Sanchez.
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours and then Lyon County come and got him before.
I noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mhm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster explained that she could not take any action against the defendants who failed to appear because there was no evidence on file showing that they had been properly notified of their required court date. Ordinarily, when someone knowingly misses a scheduled appearance, a judge has the authority to issue a bench warrant for their arrest. In Kansas, for example, Section 19439 of the state statutes allows judges to hold individuals charged with county code violations in contempt of court and issue a bench warrant if they fail to appear. However, that same statute is very clear. A judge can only take such action after service of notice to appear. In other words, the court must have proof that the defendant was officially informed of the date and time they were expected to appear, while the exact details of the charges against these absent individuals are unknown. Proof of notice is a fundamental requirement. Without it, there's no legal basis to conclude that anyone willfully ignored their court summons. Judge Webster's refusal to act without this evidence wasn't hesitation. It was a matter of due process and judicial integrity.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well,
I can print you off the copies that I got
now,
sent.
copies. I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so
Well, even with the long form, I would accept, you don't have the originals, Arlene? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why?
Well, because that's the clerks.
Well, Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets, and I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
if I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Ms. Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. In fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant, and you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
My secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss Gillette, you are not listening to me, and you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
During the exchange, Ms. Gillette asserted that prosecutors are immune from being held in contempt of court. Judge Webster quickly reminded her that, as an attorney, she still carries ethical obligations that apply to everyone who practices before the bench. Legally speaking, prosecutors do enjoy a degree of immunity, but not in the way Ms. Gillette suggested. In the landmark 1976 U.S. Supreme Court case Imbler v. Packman, the court ruled that state prosecutors acting within the scope of their duties, initiating or pursuing criminal prosecutions, are absolutely immune from civil lawsuits for damages. The court reasoned that this protection, though it may at times leave a genuinely wronged defendant without recourse, serves a greater purpose, ensuring that prosecutors can perform their duties vigorously and fearlessly without fear of constant litigation. However, that immunity applies only to civil suits for damages, not to courtroom behavior. It does not shield prosecutors from being held in contempt by a judge if they engage in misconduct during proceedings. Under Section 21,203 of the Kansas statutes, judges have explicit authority to punish acts of direct contempt, which Section 201-202 defines as any contemptuous act committed in the presence of the court. There's no language excluding prosecutors from this authority. In fact, precedent supports the judge's discretion. In the 1877 case in Reprior, the Kansas Supreme Court affirmed that an attorney can be held in contempt for insulting or disrespectful language or conduct in the courtroom. The court emphasized that an attorney is under special obligations to be considerate and respectful in his conduct and communications to a judge. He is an officer of the court, and it is therefore his duty to uphold its honor and dignity. With this privilege goes the corresponding obligation of constant courtesy and respect toward the tribunal. A failure to extend this courteous and respectful treatment is a failure of duty, and may be so gross a dereliction as to warrant the exercise of the power to punish for contempt. Although no Kansas case law appears to support Ms. Gillette's claim of prosecutorial immunity from contempt, she mentioned she had briefed the matter, suggesting she may have developed a colorable legal argument, one that would be interesting to examine in detail. Still, even if prosecutors in Kansas were somehow immune from contempt proceedings, Judge Webster's reminder stands firm. Attorneys are bound by ethical and professional conduct rules. According to Rule 3.5d of the Kansas Rules of Professional Conduct, a lawyer shall not engage in undignified or discourteous conduct degrading to a tribunal. That means Ms. Gillette's tone and demeanor toward Judge Webster, depending on how far they cross that line, could expose her not to contempt, but to professional discipline for violating ethical standards.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Miss Gillette. At this time, Missy, it looks like Miss Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
It remains unclear whether Ms. Gillette faced any formal disciplinary action following this exchange. However, she has since appeared in court again, and by all accounts, her working relationship with Judge Webster appears to have returned to good standing. This incident underscores an important truth about the justice system. While prosecutors do enjoy a certain degree of legal immunity, they are not immune from accountability. Every participant in the judicial process, whether a judge, attorney, or citizen, must respect the same procedural and ethical boundaries that keep the system fair and functional. Judge Webster's conduct in this situation deserves recognition. She refused to issue warrants without clear, lawful authority to do so, even when she trusted that the prosecution's information was accurate. By requiring the county attorney's office to fulfill its administrative responsibilities, Judge Webster demonstrated impartiality and integrity, extending no special deference to the government that she would not also extend to an ordinary citizen. At the same time, it's important to remember that a single emotional moment does not define Ms. Gillette's professionalism or ability as a county attorney. Procedural frustrations are a part of nearly every job, and while her outbursts may have crossed a line, it serves as a human reminder that none of us are immune to bad days. If there's another courtroom exchange, legal case, or judicial moment you'd like us to explore, let us know in the comments below. Thank you for watching, and don't forget to subscribe, share, and stay informed as we continue shedding light on how justice truly works behind the bench.